My topic, as you see, is entitled Equalization of What? Or more appropriately, Equalization of What? When a client comes to me for the first time to sit down and their marriage is falling apart, they've got lots of issues they want to talk about. If they're children, they want to find out about how does custody work, child support issues, spousal support issues. But inevitably, they'll get down to, okay, well, how do we divide up our property that we've acquired during the marriage? And people have lots of misconceptions about how it works in Ontario. A lot of people think we have a community property regime where what's yours is mine and what's mine's yours and everything's shared equally. That's not how it works. In Ontario, we have a system which is called an equalization of net family properties. So if I'm sitting with a client for the first time and I pull out that phrase, they continue to look at me as if I'm right out of my mind and they haven't got a clue as to what I'm saying. So what I'll normally then do is explain to them what an equalization of net family properties is an equal sharing of the wealth accumulated during the marriage and through your own efforts, with exceptions. There are always exceptions. We're lawyers. We have to have exceptions.
Hello, everyone. I'm speaking about equalization of net family property for common law couples, so I'm going to be very brief. The Family Law Act in Ontario defines spouse as either of two persons who A, are married to each other, or B, have together entered into a marriage that is voidable or void in good faith on the part of a person relying on this clause to assert any right. Therefore, when we apply this definition to issues of property division and equalization of net family property, as Tim was speaking about, we are forced to come to one conclusion. Common law couples do not equalize their property when they separate under Ontario law. Thank you.
Thanks, Michelle. You'd be surprised how many common law couples come and expect to get half of their spouse's stuff. And it doesn't happen. But that's not the end of the story because we're lawyers. And lawyers have been around for a long, long time. And long, long before family law, there was recognition that the law was not fair. We're talking about, back when people were getting beheaded and drawn and quartered and things like that. And, some people may have thought that's the way their marriage ended. But there was a idea that some things that the law did were not fair. And laws could only do justice based on the law. They could not do law based on fairness. So the law could be applied, and it could be applied unfairly.
As John indicated, I'm going to deal with some immigration issues. But to begin with, I have to tell you a story. This relates to a Canadian citizen woman who 50 years ago went abroad, married a foreign national, and sponsored the individual, brought him to Canada. Here they are 50 years later, they're sitting, having dinner together, celebrating their 50th wedding anniversary. And he looks at her and he says, 50 years ago, we had a cheap house, a junky car, we slept on a sofa bed, and we watched a 10-inch black and white TV. He says, but hey, I got to go to sleep every night with a hot 23-year-old Canadian citizen woman. He says, now I have a $750,000 home, I have a $50,000 car, a nice big bed and large flat screen 50-inch TV, but I'm sleeping with a 73-year-old woman. So the wife, without flinching, and he says to her also, it seems to me that you're not holding up your side of things, your end of the bargain. So without flinching or batting an eyelash, she looks at him and she says, okay, you go out and find yourself a hot Canadian 23-year-old young woman, and I will make sure that once again you will be living in a cheap house, driving a junky car, sleeping on a sofa, and watching a 10-inch black and white TV. So that's my introduction to my topic of as John mentioned, the intersection of immigration law and family law.
All right, so as John mentioned, I'm going to be speaking about bad ideas in custody and access cases, thinking and strategies to avoid, or how to lose your custody and access case. So there's a movie out right now called Into the Woods. And so this is a lyric from one of the songs in it. I thought it was pretty appropriate. Careful the things you say, children will listen. And careful the things you do, children will see and learn. If you're in a custody and access case, you should certainly keep that in mind. So here are some of the basics. In pretty much every custody and access case, this is the premise that the court starts out with. The children or the child of the marriage love both of the parents. The children need guidance from both of their parents, and the children should not be subject to the stress that the parents are suffering as a result of the separation.
Rachel just relayed, I'm going to talk to you today about difficult spousal support issues post the introduction of the Spousal Support Advisory Guidelines. I will refer to these throughout as the SSAGs. So you'll notice on the first slide, I posed the question, the SSAGs, friend or foe? Well, I'll talk a little bit about the SSAGs first and we'll address that question at the end. However, the SSAGs were released in 2005 and finalized in 2008. They were developed to bring more certainty and predictability to the determination of spousal support under the Divorce Act. Now, that said, the SSAGs are very different from the federal child support guidelines, which are the legislation that governs child support. They have not been legislated, nor are they mandatory. They are purely advisory. They're a practical tool used to assist spouses, lawyers, mediators, and judges in determining the amount and duration of spousal support.
So I'm here to talk to you about restraining orders and keeping your scary spouse away. What is a restraining order? This probably isn't really new to any of you, but it is a court order that requires a party to do or refrain from doing certain acts. If a party fails to comply with such an order, he or she faces criminal or civil penalties.
Today, I'm going to be talking about why going to family mediation without consulting a lawyer is like playing dodgeball blindfolded. So, legal knowledge and clarity of process. Lawyers provide critical information about family law concepts and how the law applies to a party's specific circumstances. So it is critical that a party understands key concepts such as property division, child spousal support, custody, access, parenting issues, and their interrelationships. As you've heard from my colleagues, these are very complicated issues, and if you're going into a mediation without this knowledge, you're doing yourself a disservice. Lawyers help to assess legal issues and provide advice. We set out a framework for advancing the issues at mediation. We clarify why mediation is being considered. Are you considering the mediation for cost and efficiency, control of the process? We will also go over, is the case appropriate for mediation? I.e., is there domestic violence issues? Are there power imbalances that might make the process inappropriate? We're going to explain the purpose of mediation, what it is, what it isn't, what needs to be accomplished.
My topic is called How to Keep Yourself from Getting Played, the Benefits of Entering into a Marriage Contract or a Cohabitation Agreement. Common question we have is, what's the difference between a marriage contract and a cohabitation agreement? Well, marriage contracts are agreements made by two people who are intending to get married or who are already married to each other. It doesn't have to be done before people are married. A cohabitation agreement, on the other hand, is an agreement made between two people who are living together or intend to move in together and who are not married to each other. So what happens when people enter into cohabitation agreements and then they get married? Well, automatically, cohabitation agreements will become marriage contracts if people get married. Therefore, when we are drafting cohabitation agreements, if there is a possibility that the parties are going to be getting married, we ensure that we include all of the terms that would be relevant to married couples in these cohabitation agreements.